Hi, I'm Hal Rounds. I want to talk to you about the proposed Article 5 Convention to amend the Constitution, and to warn you that it promises disaster. All aware Americans know our nation is in dire peril. Our debt is incomprehensible and growing at a rate impossible to really understand. Our national security has been put on the back burner as social entitlements and strange values drain and obscure the things that made our nation great. Politicians identify with their peers rather than the nation's people and covet the donations of power brokers instead of the duties of public trust. The federal government has nearly erased the protective role of the states. And otherwise patriotic and sensible Americans have turned to a solution that will finish the destruction, the Article 5 Convention. It sounds like a great way to address the problems that are crushing our nation. It is a process that is provided in the Constitution. It draws a specific path for amending the Constitution. Specific amendments have been constructed that promise correction of specific recognized problems. And large numbers of alert Americans agree that these problems are ones that need to be addressed. But it's still the wrong thing to do. Why? Because it evades the actual problem. We don't have the political will to fix the real problem, and so we will fail equally to do the proposed things. And because it rides on ignorance of the purpose of the Article 5 Convention, the original plan. And because we don't have a population of leaders who will apply wisdom rather than political biases to the trust we have given them. Because an ignorant and miseducated public will see this as the final opportunity to replace the Constitution that has been so badly taught, so badly ignored, and so badly defended. And finally, because it can cause very bad results. How does it evade the actual problem? Let's look at the proposed amendments to see. First, let's propose that we allow a supermajority of Congress to override Supreme Court decisions. Yeah, many decisions have been simply outrageous from that court. But Congress has the power right now to impeach any and all justices who make those bad decisions. They simply do not use that power. What would inspire them to override a decision of the court under the new rules? Let's propose limit federal spending to a % of GDP. Well, the bulk of spending now already goes to agencies that do not have any constitutional authority to exist if the enumerated powers are obeyed by Congress. Eliminating these agencies can reduce the spending to this proportion of GDP. Okay, well, let's limit the Commerce Clause and strengthen property rights. Well, again, if we stick to the powers allowed to Congress by the enumerated powers and abolish the impermissible agencies, we will accomplish this protection of commerce and of our property rights. How about let's give the states a power to override federal statutes? Again, if we stick to the enumerated constitutional powers, that will accomplish this objective. But, there's a but here, the states receive a bunch of benefit from the federal statutes and from the grants that come with them. So it's states who partly parasite themselves to these excesses. Well, let's set limits to the terms of incumbents of all federal offices. Yeah, okay, but that was supposed to be what elections accomplished. And yes, we can add federal judges to term limit requirements. How about let's repeal the 17th Amendment that took power from the states? This is actually a good plan, but it can be accomplished by the usual amendment process. And the fact that it is necessary shows the foolishness of a period when several amendments were proposed and pushed through all at once 100 years ago. In summary, the problems we whine about exist because we, and the representatives we keep electing, are ignoring and abusing the constitutional plan that already exists. Why would additions to the plan be better obeyed? It's like this. You notice that your home's front door is letting in cold air and bugs. What do you do about it? Do you replace the door or just shut the one you already have? How does this proposed plan ride on ignorance of the purpose of the Article 5 Convention? Well, the Article 5 Convention of the States plan was to provide, in case the Constitution as written proved to be a failure, for a peaceful way to escape calamity. When Madison, in the Constitutional Convention, proposed an amendment process, several delegates objected, asserting that the plan should be firm. Then, as recorded in Ferrand's Records of the Federal Constitution, Colonel Mason urged the necessity of such a provision. The plan now to be formed will certainly be defective, as the Confederation has been found on trial to be. Amendments, therefore, will be necessary, and it will be better to provide for them in an easy, regular, and constitutional way than to trust to chance and violence. That's what he wrote. What does that mean? Article 5 exists to avoid a violent revolution if the untried Constitution proved to be a flop. But it did not flop. So, the regular one-at-a-time amendment process is a more prudent way to sort out the needs from the whimsies. We do not have a population or leaders who are gifted with the wisdom and education necessary to entrust with the powers to revise our Constitution. Our leaders are chosen by elections bought by special interests, club-like establishment politicians, and media that holds the American system in contempt. Our education system has bred an ignorant and miseducated public, and they have been taught that the Constitution needs replacing rather than obeying or fixing. What is a runaway convention? Well, a runaway convention is a convention that ignores, deviates from, and produces results that conflict with its charter. Advocates of the Article 5 Convention make two claims regarding the possibility of a convention running away. They claim that the original 1787 Federal Convention was not a runaway convention, and they claim that the powers of the states to choose and control delegates to the convention will keep it within the bounds they intended. Both those claims are false. The claim that the 1787 convention was not running away is based on the argument that the delegates were authorized by their states, the states that sent them, to address the exigencies of the crisis that the Federation, under the Articles of Confederation, had been unable to overcome. They deny that the delegates were bound by the resolution of the Confederation Congress, which authorized the convention and strictly limited the objectives allowed to it, and instead were bound by what their states told them to do. Here's the actual resolution of the Confederation Congress that created the authority for what became the Federal Convention. Several states asked that this convention be gathered, but only Congress made it an official action. Resolution of Congress. This is from the Records of the Federal Convention, Volume 3, page 13. Resolution of Congress, 1787, February 21. Whereas there is provision in the Articles of Confederation and Perpetual Union for making alterations therein by the assent of a Congress of the United States and of the legislatures of the several states, and whereas experience hath evinced that there are defects in the present Confederation, as a mean to remedy which several of the states, and particularly the state of New York, by express instructions to their delegates in Congress, have suggested a convention for the purposes expressed in the following resolution, and such convention appearing to be the most probable mean of establishing in these states a firm national government. Resolved, that in the opinion of Congress, it is expedient that on the second Monday in May next, a convention of delegates who shall have been appointed by the several states be held at Philadelphia for the sole and express purpose of revising the Articles of Confederation and reporting to Congress and the several legislatures such alterations and provisions therein as shall, when agreed to in Congress and confirmed by the states, render the federal Constitution adequate to the exigencies of government and the preservation of the Union. That is the charter that created the convention that led to our Constitution. This is the reference point for judging whether the convention was a runaway, not the various requests or orders the states gave to their delegates. Arguers that it was not a runaway convention use the recommendation of their states for the convention as the same as a call for the convention. But wanting it and authorizing it are two different things. The states wanted it, but had no power to call it. Let me illustrate. Your kids and their friends want to have a sleepover. You agree to let them do this in your family room, but you forbid them from using alcohol. They come, several of them having agreed among themselves to booze it up. It turns into a drunken disaster. So, whose point of view do you take to judge whether it was a runaway party? The host, who authorized the gathering but put limits on it? Or the kids, who attended and had agreed among themselves to bring the booze? Why would we use the various purposes assigned by the states to their convention delegates to be the point of reference regarding whether it ran away, instead of the Congress that called it? We wouldn't. And when the delegates to the Federal Convention openly recognized, when they abandoned the limit to amend the articles and chose instead to design a wholly new plan, they knew they were exceeding their authority. Here are some of the comments they made in the convention. On May 30th, 1787, Randolph of Virginia proposed a resolution that the limited authority given by Congress, quote, will not accomplish the objects proposed by the Articles of Confederation, namely common defense, security of liberty, and general welfare. So, in considering the question, Mr. Pinckney of South Carolina observed that if the convention agreed to Randolph's resolution, it appeared to him, Mr. Pinckney, that their business was at an end, for, as the powers of the House in general were to revise the present Confederation and to alter or amend it as the case might require, to determine its insufficiency or incapability of amendment or improvement must end in the dissolution of the convention. On June 16th, Mr. Lansing of New York said, to determine our powers, we must look at the instruction of those who sent us. Their language allows, and he writes it this way, revision of the present Confederation to alter and amend such parts as may appear defective. It is in vain to adopt a mode of government which we have reason to believe the people gave us no power to recommend. On the same day, Mr. Patterson of New Jersey said, if the subsisting Confederation is so radically defective as not to admit of amendment, let us say so and report its insufficiency and wait for enlarged powers. 3 days later, Alexander Hamilton in the convention said, my situation is disagreeable, but it would be criminal not to come forward on a question of such magnitude. I am convinced that no amendment of the Confederation can answer the purpose of a good government. Let us now review the powers with which we are invested. We are appointed for the sole and express purpose of revising the Confederation and to alter or amend it. I can say for the state I have the honor to represent that some members were for inserting a restriction in the convention's powers, but they did not limit me. I have, therefore, no difficulty as to the extent of our powers, nor do I feel myself restrained in the exercise of my judgment under them. We can only propose and recommend. The power of ratifying or rejecting is still in the states. So, with Hamilton's admission that his state allowed him to go beyond the limits set by Congress, we have clear proof that the convention was running away, and that the delegates knew that is exactly what they were doing. After the convention had invented this entirely new plan we call the Constitution, contrary to their charter, The plan had to be approved by conventions of the people of the states. Now, many were concerned that the convention had exceeded their limits and so had produced an illegitimate proposal. The Federalist Papers were the most influential series of arguments working to persuade these conventions that the Constitution should be ratified. The whole argument of Federalist number 40 was that the new plan did retain some parts of the Articles of Confederation, so their authority to amend was mostly obeyed. Right. The overall plan did abandon the structure and rules of the Articles, but the objective of providing for the happiness of the people was more important than sticking to the limits given, or so Madison argued. It's kind of like being told to weed the garden, and instead digging up the whole thing, throwing out most of the flowers, and rearranging those you kept, putting them among a whole new carload transplanted from somewhere else, is just amending the garden. No, it's rebuilding it. And at the conclusion of Federalist number 40, Madison shows us why it had to be a runaway convention. He said, "The prudent inquiry in all cases ought surely to be not so much from whom the advice comes, as whether the advice be good." And the answer to his statement there is the national success that has blessed us all from that day until now. That runaway convention was a success. Can we trust that the people we might send today and those of other states will be gifted with equal wisdom as our founders? Our only governing disappointments have come not from the Constitution, but from deviations, distortions, and disobedience of it. Failure to understand it does not justify amending it, particularly with a process for amending so uncontrollable. But if all those delegates recognized that the Federal Convention of 1787 ran away, just what did that runaway consist of? It created 3 branches of government, where the Articles had only one. It created a power to tax directly with excises and duties and so on. It gave a series of enumerated powers to Congress: bankruptcy, commerce, coining money, and so on. It created, as one of the branches, the office of President, which many feared would lead to a monarchy. And it established supremacy of valid federal statutes over state laws and constitutions. Perhaps most dramatic of all, it changed the rules for changing any major plan in government. The Articles of Confederation had required, for amendments, unanimous approval by the states in their legislatures. But the Constitution required, for ratification, 3/4 of the states, not all of them, in conventions of the people of the states. Now, legislatures can ratify routine amendments, but that initial conventions of the people was a key difference that deviated from the authority of the Articles. And that is the central demon that requires us to oppose the Article 5 Convention. What can the Article 5 Convention do that's so bad? Well, first, there is no limit to what the delegates can propose. Article 5 says the convention is to propose amendments. It does not say that any one state can limit the others to certain topics, nor can Congress. It is a free-for-all. So, how popular is the Second Amendment in the big states today? How about, have you heard kids and teachers who want to suppress the freedom of speech because blunt speech can make them feel bad? How popular is the Electoral College that keeps the smaller states from being run over by the larger ones? Do the people really know how to avoid the entitlement program system that is causing such devastation to our economy? The list of bad ideas desired by a horribly educated populace is endless. Second, there's no guarantee that the power to ratify these horrors will be protected by the 3/4 of the states ratification rule, because that is subject to amendment as much as any other part of the Constitution. And miseducation has left the voters of America ignorant of the purpose for that restraint that protects us from dangerous political fads. Let's propose just one amendment. Ratification of any amendment from the Article 5 Convention will now require 50% of the population of the United States plus one person. This eliminates the role of the states in ratifying. It eliminates the power of any minority to protect their rights under the Constitution. And the voice of a state the size of Tennessee will be less than the voice of Los Angeles. There is no power of the Tennessee State Legislature to prevent any delegate from voting for any foolish measure in the convention, because it is held under the authority of the Constitution, not of the state. The Constitution already provides that senators and congressmen, quote, shall be privileged from arrest during their attendance at the session of their respective houses, and for any speech or debate in either house, they shall not be questioned in any other place. That makes them immune. The same rule will likely be offered to protect the delegates from any punishment for violating their instructions from the states. This is a promise that the proposed Article 5 convention will be a disaster. Call your representatives to assure they know you oppose the Article 5 convention. If you are a representative, coach your colleagues regarding the bad things this fad secretly promises. We must not let an Article 5 convention happen. Thank you.